Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Submitting evidence in family court is a critical step in presenting your case, but it's a process with specific rules you must follow to ensure your information is properly considered by the judge. This isn't just about bringing documents, it's about making sure the court can legally accept and review what you're trying to show them. First, you need to understand what constitutes evidence. This can include documents like bank statements, pay stubs, medical records, or school reports, as well as photographs, videos, text messages, emails, and even witness testimony. Every piece of evidence must be relevant to the issues in your case, meaning it directly relates to the decisions the court needs to make, like child custody, support, or property division. Not all relevant evidence is admissible, which is a key distinction. Admissibility means the court's rules of evidence allow it to be presented. For example, hearsay, which is an out-of-court statement offered to prove the truth of the matter asserted, is generally not admissible unless it falls under a specific exception. You also need to establish authenticity, proving that a document, photo, or message is genuinely what you claim it to be. For instance, you might need to testify about where a photo was taken or who sent a text message. Laying a proper foundation is crucial. This means you must explain what the evidence is, how you obtained it, and why it's important to your case before the judge will consider it. During the discovery phase, which happens before trial, you and the other party will exchange information and evidence. This includes disclosures where you list the evidence you intend to use and responses to requests for production, which are formal requests for specific documents. Organizing your evidence is vital. Create an exhibit list, which is a detailed roster of every item you plan to introduce, and label each item clearly with a unique exhibit number or letter, such as Exhibit 1 or Exhibit A. You will need multiple copies of everything. One for yourself, one for the other party, and one for the judge. Before trial, during a pre-trial conference, the judge might review your exhibit list, and you might even file motions in limine, which are requests to the court to either include or exclude certain evidence before the trial even begins. When you are actually in court and want to introduce an exhibit, you must formally ask the judge for permission, stating, "Your Honor, I would like to introduce what has been marked as Exhibit A." Then you must lay the foundation by asking questions or testifying yourself to authenticate the exhibit and explain its relevance. The opposing party will have an opportunity to object to your evidence, perhaps on grounds of relevance, hearsay, or lack of foundation, and you should be prepared to argue why your evidence should be admitted. Witness testimony is often used to introduce and explain other forms of evidence, with a witness testifying about the authenticity or meaning of a document or photo. Always remember to consult your specific states and local courts' rules of civil procedure and evidence, as these can vary significantly and dictate the exact steps you need to follow. Understanding these rules is essential for a successful presentation of your case. Thank you for watching this video on how to submit evidence in family court. We hope this information helps you navigate what can be a complex process. Please remember that this content is for informational purposes only and is not legal advice. You should always consult with a qualified attorney for advice tailored to your specific situation. If you found this video helpful, please give it a thumbs up, leave a comment with any questions you have, and don't forget to subscribe to our channel for more helpful legal tips. Hit that notification bell so you don't miss our next video.